Hi, everyone, and welcome to the second installment of the Legal Landscape series, sponsored by the Credit Research Foundation and Lowenstein Sandler. I'm Mike Papandrea, and this is my colleague, Keara Waldron from Lowenstein's Bankruptcy and Restructuring Department. In today's episode, Mind Your Ordinary Course of Business, we're going to be discussing recent developments in the case law regarding the subjective ordinary course of business preference defense.
As many of you are likely aware, Section 547 of the Bankruptcy Code allows a debtor in possession or trustee to claw back certain payments that were made in the 90 days prior to the petition date, commonly known as the preference period. This preference statute is intended to promote equity among similarly situated creditors and deter a debtor from paying certain preferred creditors at the expense of others. While equitable in nature, the preference suit leads to some harsh results to creditors who are just trying to work with a distressed company.
Today we're focusing on one of the most common defenses to a preference claim, the subjective ordinary course of business, or OCB, defense under Section 547C2 of the Bankruptcy Code. In order to prevail on a subjective OCB defense, the defendant creditor must prove that the alleged preference payments were on account of and made in the ordinary course of business between the parties. To do so, the defendant typically establishes a historical baseline from prior to the preference period to compare against the timing and nature of payments made during the preference period to show that the payments made during the preference period were in fact ordinary and consistent with that historical baseline.
The inherently subjective nature of the defense has given rise to a myriad of methodologies that parties rely upon to demonstrate what is ordinary. Courts consider a variety of data points, including what's the proper historical period to consider, i.e., how far back do we look? Does the historical period contain outliers, which may not otherwise be indicative of the ordinary course between the parties? Should the historical period be limited to when the debtor was financially healthy? And how should the court interpret all these various data points to determine what is or is not considered ordinary? There's no one single method that courts will rely on, and as a result, decisions are really all over the map.
The law is always evolving, so it is important to stay on top of how courts are interpreting and applying the subjective ordinary course of business defense. Although not always foolproof because the defense is, subjective, staying informed and using recent decisions to inform your decisions when dealing with distressed customers can ultimately help position you in the event that you're eventually hit with a preference suit down the road. Today, we'll start with the good news, 2 decisions that were relatively creditor-friendly, followed by a decision that provides a cautionary tale for creditors. The first and most straightforward decision is a recent decision issued in the Chapter 11 cases of J&M Sales by the United States Bankruptcy Court for the District of Delaware. In J&M Sales, the court used the most simple and the broadest preference analysis available, the total range method. Using the total range method, the court looks at the total range of days to pay for invoices issued and paid during the historical baseline period to compare the days to pay for invoices issued and paid during the preference period against in order to determine whether the preference period payments were in fact ordinary. This analysis is very beneficial to creditors because it inherently gives the broadest possible window within which to assert that the preference payments were ordinary.
In another case, in Décor Holdings, the Bankruptcy Court for the Eastern District of New York went with a different method. The court rejected a pure high-low analysis in favor of what's called an average lateness method. While the average lateness method typically compares the average days late or days past invoice due date during the historical period and the preference period, the court in Décor Holdings rather compared the average days to pay or days past invoice issuance date during the historical period and the preference period, and then compared those 2 averages to determine if there was a material difference. Courts differ on what constitutes a material difference. The court in Décor Holdings held that a difference of 7 days to pay was not material, so therefore all the challenge preference payments were considered ordinary. The average lateness method is beneficial to creditors because it provides a little more wiggle room in what might be considered ordinary.
So the J&M and Décor Holding decisions provide great examples of how a creditor can establish a successful subjective ordinary course of business defense. But what if the creditor had asserted some collection pressure in the period during or prior to the preference period in order to ensure that it received payments on its accounts receivable? If that had made it such that the payments made during the preference period were not ordinary? These questions were addressed in the recent cautionary tale by the United States Bankruptcy Court for the Southern District of Indiana in the Chapter 11 cases of H.H. Gregg.
In H.H. Gregg, one of the debtor's key suppliers was sued for a preference suit in the amount of $4.7 million. The creditor presented what would otherwise be an airtight, subjective OCB defense. The creditor was able to demonstrate that the days to pay during the pre-preference period and the preference period were nearly identical. There were other factors that also weighed in favor of the subjective OCB defense. The supplier never withheld shipments. They never threatened to commence litigation or demanded any guarantees from the debtors or their principals. The court also noted that the supplier actually increased sales to the debtors during the days prior to the bankruptcy filing, even though the debtor was in extreme financial distress. This was something that Congress had actually sought to encourage in drafting the preference statute.
It's worth noting two interesting side points from the court's analysis. First of all, the court held that it was appropriate for the creditor to rely on a days late analysis rather than a days to pay analysis because the credit terms between the parties had changed during the historical period. Since the credit terms had changed, if you had just used a days to pay analysis, the analysis would have yielded an unreliable comparison to compare the historical period with the preference period. Second, the court held that the historical baseline to be used by the creditor should be limited to a period within which the debtor was quote-unquote financially healthy. And as a result of this, the court held that it should disregard a 10-month period leading up to the preference period because during that 10-month period, the debtor was under financial distress. Of course, this holding is bad news for creditors to the extent it's followed in other cases because it restricts the period within which a creditor might look to in order to establish that the payments made during the preference period were ordinary. That said, this holding didn't really have much of an impact on the decision in H.H. Gregg because the court nonetheless held that the creditor had proved that the timing and nature of payments made during the preference period were in fact consistent with the timing and nature of payments made during the historical, albeit truncated, baseline period.
The bad news for the supplier, however, well, the evidence also showed that the supplier had ramped up its collection efforts in the days prior to the petition date, largely in response to the debtor's disclosure in financial reports that it had underperforming sales and a declining share price. While the supplier had previously provided the debtors with a credit limit of $10 to $12 million, it steadily began decreasing that credit limit to the point where it was reduced to just $1 million. The supplier also reduced its credit terms. All of this resulting in the supplier having ultimately been overpaid as of the petition date. And finally, the supplier escalated its collection efforts slightly prior to and during the preference period by copying or directing its communications to senior executives and threatening to withhold future shipments in the event of non-payment.
And what the court had admitted was not an easy call. The court ultimately held that the creditor had failed to establish its subjective ordinary course of business defense in light of the potential impact that the payment pressure might have had on the timing and nature of the debtor's payments during the preference period. In other words, the creditor had failed to tip the scales in its favor in proving its defense. This is, of course, bad news for creditors, but that said, creditors can take solace in the fact that this H.H. Gregg decision is but one decision by one court in one preference suit and isn't necessarily binding on any other courts, including itself, even on similar facts.
In fact, in a subsequent decision in another H.H. Gregg preference suit, the court concluded that emails inquiring just about payment status, but not threatening to impose credit limits, tighten terms, or take other collection efforts, did not negate the creditor's subjective OCB defense. Still, the prior H.H. Gregg decision nonetheless serves as a cautionary tale for trade creditors who are seeking to manage their credit risks in the days prior to a bankruptcy filing. Ultimately, creditors will have to weigh the pros of getting paid now with the cons of a potential preference suit down the line, and should be aware that the more unusual or extreme a collection effort, the more likely at risk your subjective OCB defense will be.
As demonstrated by the cases we've discussed here today, when it comes to the subjective ordinary course of business defense, consistency is key. Just as consistency in the timing and nature of payments between the historical and the preference period are when establishing the defense, consistency in the collection efforts by the creditor is also key in ensuring that the creditor's defense is in fact preserved if and when it might get hit with a preference suit. That's all we have for you today, but stay tuned. Here at Lowenstein Sandler, we're constantly keeping an eye on and keeping others updated on interesting developments in the bankruptcy and restructuring space. Until we see you again, thanks for tuning in today.